Well, good evening, everyone, and welcome back to AJ103, Criminal Evidence Online. Tonight's lecture is on Chapter 8, which is going to include documentary evidence, models, maps, and diagrams. Now, a lot of information, again, that's going to be brought forth in this chapter, so please take the time to go through and read the chapter as well, along with specifically focusing in on the example areas that correspond with a lot of the main topics that we're going to be discussing. So with that being said, let's jump right into the lecture so we can keep within our time frame. Now, what I have for you here is a really unique case that shows the investigative tools as it relates to homicide and a forgery case, and how we can use signatures and forged signatures, if you will, and the tests and analysis that come with those to help solve certain types of crimes. And in this case, there is a handwriting comparison portion, which is extremely important. So while it's about 45 minutes long, it's a really good case that can show you how we investigate these types of crimes and how we can use handwriting experts and other comparison experts like forensic document examiners, if you will, to help solve crime. So take the time to look at this one. So our featured case for tonight is going to be the Bernie Madoff case. Now, starting in 1991 and continuing until 2008, Bernie Madoff ran the largest Ponzi scheme in history, and somewhere between $18 and $65 million were stolen. Now, he was investigated 6 times between 1992 and 2008, and until proof finally surfaced to prove his guilt. Now, Madoff's brothers and 11 others were also convicted in this particular crime. So when we look at this case, and again, it's only 2 pages that you can kind of read it pretty quickly, individuals are far more likely to be the victims of white-collar crime rather than street crime. But cases like the Madoff case are typically rare, and most white-collar criminals receive less jail time. So should the overall damage to society be part of assessing the criminal penalties? And why is it worse to steal $1 from a person with a gun than thousands of dollars from somebody else by fraud? Is it 10 times worse to steal $10 million versus $1 million? And if you think that's true, then why is it? So these are questions that you could kind of ask yourself as you read through this case study a little bit more. So what are we going to learn tonight? Well, the hope is that we can explain what documentary evidence is, and we can describe the authentication rule and explain what a forensic document examiner does and who is that, and identify the hearsay rule, and then explain how maps and models are admitted and used in court. So some myths and some facts. The myth being first here, the category of documentary evidence only covers documents that the parties intended to have legal consequences. Well, we already know all types of documents are covered by this category, regardless of the intent of the parties making the document. And the term document only covers things written on paper. Well, that's not really true. The term covers things on paper as well as photographs and audio recordings and videos and computer files and digital data. And then the hearsay rule does not apply to written documents. Well, you'll find out that it applies to both oral and written. And if you don't know what hearsay means, then you'll find out soon what it actually means. So as an interesting pre-test, I gave you this, and you can do this at your leisure. And basically what you're going to do is the link below will take you to this little exercise, if you will. And when you get there, it's a handwriting exercise, and you'll see it. And maybe I'll click on it real quick so you can kind of see it. I'll do that for you. So you're going to get here, and you're going to go to handwriting analysis, and you're going to hit begin, and you're going to see what you saw on the other screen. Now, while you have the screen open, you're going to be the handwriting expert, the forensic analyst that's going to compare these with these. So the object would be to take the top one, let's say in column A, and then find the corresponding one in column B. Which one do you believe that it possibly is? And we can try one. So let's click on the first one. And then I know you can't help me because you're busy doing other stuff and you're actually doing this lecture, so I get that. But experts will look and be able to tell as they go through these which one that they think it might actually be, and they can base it on some letters or a bunch of letters. And let's see if this is it. Bam! Okay, so I got one right, and I'm going to leave it at that because I'm 1 for 1. And then you'll go here and do this one and compare it to that one and so forth, and you'll be able to see how good you are with just your eyes to kind of check that out. So it's kind of an interesting game, but this will give you a chance to be the forensic analyst for the day. So let's talk about documents and the definition and what they are. So in the Federal Rules of Evidence, the term document is considerably different than what is used in everyday conversation. And it's anything containing letters, words, numbers, pictures, or sounds, whether on paper or other substance, is classified as a document. And generally speaking, documents can be divided into writings or recordings or photographs. Now, the term documentary evidence, more commonly referred to as documents, applies to items ranging from a handwritten letter to information stored on a microchip or graffiti on a wall. So make sure you keep in mind or keep this in mind as we kind of study this chapter. So in addition to being relevant, because we know that evidence, in order to be admitted, any type of evidence, right? We've learned that through several chapters. It has to be relevant. So in addition to being relevant, all types of documents have to be authenticated before being admitted into court. And an authentication means that the party who wants the document to be admitted at trial must establish that the document is in fact what it claims to be. So that's the authentication process. Now, here's kind of a little exercise that we'll do. So for example, suppose I take a piece of paper and I write on this 4 + 2 = 9, and I sign it. Now, it's obvious that my addition is not accurate. However, if we were all in the classroom together and I did this in front of you, if this piece of paper were to be introduced into court, you could in fact authenticate it. Well, why? Well, the reason is because you saw me prepare it. You saw me write it. So you would in fact be able to authenticate it. Does that kind of make sense to everybody? So if we were all together and you saw me write this out, even though it's wrong, we're not talking about the math, we're talking about the document. You would be able to testify that, hey, I watched him write that lousy math problem. So the reason, though, for this whole authentication requirement is to prevent a person from introducing fraudulently created documents. And authentication also protects in a situation in which a person claims that a proposed contract is binding when in fact the negotiations on the contract may have broken down and no contract was really ever finalized. So federal rules of evidence at the FRE, remember there's a lot of stuff in there, 901 provides a long list of ways to authenticate documents. And we're going to kind of take a look at some of those. And I'm going to touch on them. I'm not going to read every single definition of each one, but I'll go through these. So in general, in Federal Rule 901, in general, to satisfy the requirement of authenticating or identifying an item of evidence, the proponent, the one who wants it introduced, has to produce evidence sufficient to support a finding that the item is what it's really claimed to be. And here are, again, some of those ways to authenticate. Now, if you're following along in your textbook, I'm at the very bottom I'm at the top of page, I think, 211. So the first, testimony of witness with knowledge. So testimony that an item is what it's claimed to be. Number two, non-expert opinion about handwriting. Well, a non-expert's opinion that handwriting is genuine based on familiarity, meaning I'm familiar with the person's handwriting, is okay for litigation. So you can do that. Comparison by an expert witness or the trier of fact. So a comparison with a authenticated specimen by an expert witness or trier of fact. Distinctive characteristics and the like, so the appearance, contents, substance, internal patterns, or the other distinctive characteristics of the item taken together with all the circumstances. Now remember, these are examples, okay? So to satisfy the requirement of authentication, if you will, or identification, we have to produce evidence sufficient to support the finding that the item is what it really is, and that's what we're talking about here. So voice identification. Well, an opinion identifying a person's voice, whether heard firsthand or through mechanical or electronic transmission, based on hearing the voice at any time under circumstances that connect it with the alleged speaker. And some other ones, telephone conversations by a particular person, or number or location of call, ancient documents based on condition, location, and age, or process or system, which is evidence that describing a process or system and showing that it produces an accurate result. And then the last one, method provided by statute or rule of law. And this would be any method of authentication or identification allowed by a federal statute or rule prescribed by the Supreme Court. So these are just some illustrations, if you will, that we've gone over, okay, that talk about ways to authenticate documents. So, and those are on page 211. So we've kind of walked through there. Well, what about Are there documents that are kind of, that you don't have to do any of that other stuff? Are they self-authenticating? Well, self-authenticating documents are those that the law automatically assumes were made for their apparent purpose. And usually a seal or some other identification of authenticity is on it or attached to it, etc. And even with self-authenticating documents, the opposing side can show that they are fraudulent, so they can do that. Now, Rule 902 of the Federal Rules of Evidence lists 12 types of self-authenticating documents, and we're not going to go through all of them. We're going to pick some of the more frequent ones, but back to the self-authentication thing. So what about a certificate of authenticity? You know, when you buy your favorite autograph that's on a baseball or on a football. Would this be self-authenticating? So again, some documents carry a presumption of admissibility, and they usually need a seal or some other identification or authenticity that's either on or attached to the document. And some ones that we could probably talk about. What about a birth certificate? Well, that's going to be one. So that's one of these self-authenticating documents, or perhaps even a official certification of nomination. And this is the one that was used by Barack Obama and Joe Biden. So could these be self-authenticating? Well, I think they probably could. What about a newspaper? Could that be self-authenticating? So kind of interesting. So under Rule 902 that we talked about, there's 12 types, and we're going to I'll list them all, but we're only going to kind of really focus on a few because there are just, again, so many, and I don't want to spend the time on going all over everything. So domestic public documents under seal, so sealed government documents. Certified copies of public records. Newspapers or periodicals. Those are good. So those are a couple of things that are self-authenticating. And then you have trade inscriptions and foreign public documents and some more. Certified domestic records of regularly conducted activity, and presumptions under acts of Congress, and a commercial paper, and acknowledged documents, and all this. But we're going to cover the ones that I spoke of, and these are the ones that are typically that you'll run into, because we really don't have a chance to go through all 12. So sealed government documents. As used here, government documents include all public documents that are made by the federal, state, or local governments. Now, these government documents are self-authenticating if they bear an official seal and are signed by someone with authority to state that the document is genuine. And certified copies of let's say, public records are also self-authenticating. And a certified copy is usually signed by someone working at the clerk's office, and a paragraph is usually added to the document that states that this is a true copy of an official document, and then it's signed and in many states sealed. So births, deaths, marriages, and divorce are usually established by certified copies. Prior convictions are also introduced into evidence by producing a certified copy of the original court record of conviction. And then, like a death certificate or a birth certificate. So all of these are those. Well, then we come to like notarized or acknowledged documents. Now, a person who is a notary republic is licensed by the state to witness the signing of documents. And part of the training to be a notary focuses on the proper types of identification needed in order to verify that the person signing the document is in fact whom he or she claims to be. The statement added by the notary public states that the signature is authentic, and sometimes a notary will state the intended purpose of the document, that is, like in a deed or a will. And this document is self-authenticating for that purpose stated. So what about the second half of that, like an acknowledged document? So we talked about notarized. Well, what's an acknowledged document? Well, the exact word of an acknowledgement is established by state law. Now, different forms may be used for different purposes. A notary public signs an acknowledgement, and California law specifies the content of that acknowledgement. Now, if you look on page 214, there's going to be an example of an acknowledgement, and you can kind of take a peek there and it'll give you some more information. Well, official publications. Well, official government publications are self-authenticating, and these documents include the officially published codes and case reporter. Now, in many states, there is more than one publisher selling copies of the state's code or codes. And law firms may purchase the one that has the best price. If it becomes necessary to take a volume of the code to court to prove the content of a code section, it is important to take the official publication to court or to double check the unofficial one to make sure it matches the official one. And when it's necessary to establish, let's say, a penal code section in court, the bound volume may be handed to the judge. Now, due to the fact that the judge can take judicial notice on all codes of the state where the court is located, it is rare for this to be done except when a law from another state is questioned. So if they're really not sure what they're dealing with. So what about some other types of self-authenticating things? Well, a variety of other documents are usually considered to have such a minimal likelihood of forgery that they are considered, for the most part, self-authenticating, like brand name labels fastened to merchandise to show the name of a manufacturer falls into that group. Commercial documents such as letters of credit are self-authenticating if they comply with the requirements stated in what we call the Uniform Commercial Code. Newspapers and periodicals fall into this group. Now, note that the newspaper is self-authenticating, but that does not guarantee that the stories are in fact accurately reported, right? So you have to kind of remember that. Well, now, what about ways to authenticate documents? And we've talked about some. So we know there's a variety of ways. And some other things that come into play we're going to talk about now. So while there are a variety of ways to authenticate documents, and there are, all of them are subject to challenge by the opposing side. And then remember, the jury makes the final decision about authenticity. They get to decide. So what about testimony of witnesses? Well, the most obvious way to authenticate a document is to call one or more witnesses who can testify about making the document in question. Now, if the document has been in the possession of the police, witnesses will also need to establish the chain of custody. So, testimony of a witness, if they have direct knowledge, kind of like when I gave the example of you watching me make that document and write on there. So the example I have for you would be a friend was at the victim's house and saw the extortion victim write the check to the person threatening him. Well, they would be able to testify to that. Does that kind of make sense? And then you have the lay opinion on handwriting. So if any part of a document is handwritten, including the signature, anyone who is familiar with the handwriting of the person in question or who saw it being written or signed may authenticate it. So from someone familiar with handwriting, how about like a spouse? Or in the example, a secretary testifies that she worked for the same boss for years and recognized his handwriting. And sorry about the spelling on boss. It says booze. But anyway, so you kind of get what I'm talking about with the lay person. So let's skip past the notarized document questions. And what about a forensic document examiner? Where does this person come into play, and what job do they do? Well, a written document can also be authenticated by the testimony of who we call a forensics document examiner, and they used to be called like a handwriting expert. And to do this job, it's usually necessary it is usually necessary to provide the expert with an example, a handwriting exemplar or a sample made by the person who allegedly wrote the document. And we'll talk a little bit more about that as we move forward in the chapter. So also some other common things that fall under this realm would be distinctive characteristics. So that would be like, a document can be authenticated by showing that it contained distinctive characteristics such as words, phrases, or doodles used by the person who allegedly made the document. Now, the fact that it contains information known only to the maker or a very small group of people can also be used as well. So now that we've kind of covered those areas, let's go back and talk a little bit more about that forensic document examiner. Because what we went through were areas that we're talking about, authentication and ways to authenticate. And now we're going to focus in a little bit more on that forensic document examiner and perhaps what they do. So a forensics document examiner may testify if the authenticity of a document is challenged. And when we mention questioned documents, we usually think of forged checks. And the term, however, can be used to apply to a broader range of things, including anything on paper, fabric, or cardboard, or even written on the walls. And although most common cases involve written or typed materials, pictures, graffiti, and other forms of graphic presentations, those can also be examined. Fake passports, diplomas, and trademarks may also be involved in a criminal case. So all of these things. So this forensic document examiner can testify for or against authenticity based on handwriting or signature, typewriter, printer or fax, check machine, stamp or label machine, printing process, ink instrument or paper. So a lot of different things. And as we talk a little bit more, the forensic document examiner again evaluates those things that I just went over in order to determine the document's validity. So if you go back, look at what they can do. So you're talking about handwriting, cursive and printing and signatures, and typewriters, photocopiers, laser printers, and fax machines, um, check writers, rubber stamps, price markers, label makers, printing process, ink, a writing instrument, and paper, and and even alterations, additions, and obliterations, and things that have been tried to have been erased, and also deciphering of intended writing, and then even sequence of stroke. The examiner can also compare computer printouts to identify the type of printer used. So they can testify on a lot of different stuff. So let's kind of look at some of the stuff really quick, and we'll go through here. So handwriting comparison. Now, as a child learns to write, his or her handwriting takes on basically habitual shapes and patterns, and these form a unique subconscious pattern, although there may be changes over time due to various conditions. Now, variations will exist in angularity and slope and speed and pressure, letter and word spacing, and relative dimensions of letters, connections, pen movement, writing skill, and even finger dexterity. And additionally, a person may develop distinctive habits of arranging his or her writing on the page, margin, spacing, crowding, insertions, and alignments. Spelling, punctuation, and phrasing and grammar may also help identify someone. And in order to determine who wrote a question document, remember, the examiner has to have an adequate sample of a person's handwriting. So handwriting comparison, skill of the examiner is of central issue. And they make a comparison to an exemplar. Well, typewriter, printer, and fax, the examiner determines the make and model. And a little more difficult with a printer, but they're able to actually determine the typewriter or printer. So the most common question involving typewriter comparisons are the following. What make and model of typewriter was used to make the document? And was the document typed on a specific typewriter? And for many years, there were only two common type sizes used on typewriters, but there were many minor variations between the typefaces used on different makes and models. And a forensics document examiner may be able to answer all of these questions if an older model typewriter was used. So what about alterations or erasures or obliterations? Well, documents may be altered or changed, or their meaning, and alter the original intent of the maker, alter important dates, or actually do a forgery. And erasures, sandpaper, razor blades, and knives are used for this particular purpose. And all of these methods can, or they do cause disturbances in the upper fibers of the paper that are apparent when the document is examined under a microscope. So, they look for any changes, hopefully, and hopefully some can be detective. And they look, about any evidence of change. What about comparisons of paper and ink? Well, ATF has a library of ink to compare samples to. And the goal is to determine when and where ink or paper was made. And these are some things that actually these forensic examiners can do. And some examples of obliterated writing would be using what they call inferred to basically decipher obliterated writing. So they're using a basically inferred sensitive film or image conversion microscopy, which is kind of like they're able to look through almost like an X-ray, where they can look through. So you can look at the photo on the left and you can look at the comparison on the right. So they can use that image conversion to see what is underneath. And some other examples might be using ultraviolet light to see what has been erased. And if you pay close attention to right here, you can see what was erased, and then of course what was written over the top. And then also, a handwriting comparison expert can look at, let's say, threats or notes or letters, and maybe pick out or be able to match the example to the actual suspect or the letter. So here you have something written to the president of the Super Cola Company, and it says here, "I'm in possession of the secret formula for Super Cola, and unless you pay a ransom of $1 million within 1 week, I will sell the formula to the highest bidder from your rival companies. I will send you further instructions on payment in 3 days." And here's your potential suspects. So can you look at these potential suspects, these 5 suspects, just based on this sentence, and compare it to this letter and tell me who the suspect is? I'll let you kind of work on that. So as we're getting closer to the completion of the chapter, we're going to talk about the application of the hearsay rule to documents. Now, all statements that are made out of court, and you'll learn more about hearsay a couple of chapters from now. All statements that are made outside of a court hearing that are offered into evidence as true fall under the hearsay rule. Now, this includes statements made orally and in documents. And hearsay typically is not admissible. But statements that qualify for exceptions to the hearsay rule are admissible in court. And not only that, there are a lot of other exceptions to the hearsay rule as well, but we're talking about statements right now. Now, the 2 most widely used exceptions to the hearsay rule that apply to documents are going to be covered in this chapter, and we'll talk about them in a second. Now, again, many other exceptions are listed, but those will be found and listed in chapter 9. So you'll have to, hold on to your hat for that exciting news to come. So generally, again, hearsay is, inadmissible. But there are a couple of exceptions for documents, and those would be business records and what we call official documents. Now, business records is established under the FRE, like everything else dealing with evidence, under Section 803. And due to the apparent reliability of records made during the normal course of business, the business records exception to the hearsay rule has been established. Vital statistics like births, marriages, deaths are a form of government record, but they are normally treated separately because the record was filed with the appropriate government agency, but in most cases, a government employee did not participate in the event described in the record. The term business includes, every kind of business, governmental activity, profession, or occupation and calling, whether conducted for profit or not. So, examples could be gun store records of purchase, or telephone records of calls, or time cards stamped for hours worked. And the requirement for business records, there are 3 basic requirements that fall under the business records exception. So they must be based on someone with knowledge of the event recorded. The record made in timely manner and in regular course of business. And the record must be commonly or regularly made by that business. And then the other part that we talked about would be like official records or public records. And this is found in FRE under 803. And typically covers any report or record made by a government agency in the ordinary course of their work. Now, this includes factual findings by the government, and it covers mandatory reports. So investigative reports are not covered and remain hearsay. So kind of a review on this one, because I know it's tough. The federal rules of evidence divide public records and reports into a couple of categories. The first is public activities, which covers a wide range of internal records and reports. Public agencies, ranging from courts to the police department, from the tax collector to the dog catcher, are covered. And any report that these agencies make documenting their own activities falls into this category, much as the business record exemption covers reports of a private agency that in the normal course of business. Now, on the other hand, embedded hearsay statements must be covered by some other exception to the hearsay rule. So just remember that public records or official records can be an exemption to the hearsay rule. Okay? So what is hearsay? Just a little bit more on that. So these are statements that are made outside of a court hearing that are offered into evidence as true, and they fall under the hearsay rule. And as I said earlier, this includes statements that are orally or information in documents. And hearsay is not admissible, but statements that qualify for exemptions to the hearsay rule that apply to documents are covered. And we talked about those business records and those official documents. So how do we introduce the document? So now we know all this hubbub about documents and everything else. Well, how do we get it entered into evidence? How do we introduce it? And this is going to be kind of important. Well, the original document is preferred when the contents of a document needs to be introduced into evidence. And at one time, this was referred to as the best evidence rule. The federal rule of evidence in many states no longer use that term best evidence, but preference for the original documents will remain. So whether a letter, a book, photograph, videotape, audio tape, or x-ray is involved, the original must be produced in court or accounted for. And we'll talk about what the original is in just a minute. So the original document, as said here, should be admitted in preference to any duplicates. And some of the definitions, when you look at these, if you look at Federal Rule 1001, it defines some terminology like what writings are considered and what recordings are and what a photograph is, and the original, what an original is, and what a public record is. So all of this information is listed in here, and you can find more on page 230. So when we're talking now about originals and documents and introducing them into evidence, we're going to have what we call primary and secondary evidence. So the original document or a duplicate is considered primary evidence when the contents of the document are at issue in the case. The original is the document itself and any copies that the person making the document intended to have the same effect as the original. Now, duplicate, sometimes called duplicate original, originally referred to copies made with the same stroke of the pen, like in carbon copies, or produced by the same negative or master printer or fixed typeset or what have you. The definition has been changed to cover the wide varieties of processes currently used to reproduce documents. So what is this then, this primary or secondary evidence thing? So primary is the original. We went over that. And there are some serious issues with computer records as the rule doesn't really fit. And primary evidence is used to establish content. Now, secondary is evidence behind or beyond the original. Okay, so hopefully that kind of makes sense. And then there's this, what we call parole evidence. And testimony introduced to show the contents of a document is in fact called parole evidence. It's spelt a little different than the regular parole that you think of. And parole evidence is not allowed to show the information in public records unless it is impossible to obtain certified copies. So again, you just need to know the definition. You don't need to know all the examples. And again, as I go through all of these, as I talk about primary evidence, there are examples that are on page 231. As I talk about secondary evidence, there are examples on page 232. And remember, secondary evidence, as a reminder, it includes all other evidence that can be produced to establish the content of the original. So what about like photographic evidence and things like that? And here's secondary evidence, as we kind of talked about. Well, photographs must meet several requirements before they can be introduced into evidence. And as is the case with every exhibit, an attorney asks the judge to allow at trial the content of the photo must be relevant to the case. And the photos must accurately portray the scene. Shots taken at angles that sort of distort the scene, they're not going to be allowed. Now, the requirements of that best evidence rule that we talked about must be met because photographs are documents, remember? And although we normally think of still pictures when we use the term photograph, that same term applies to videotapes and WAV files and X-ray files. Those are also photographs, but their admissibility is governed by the rules applied to scientific evidence. So how do we do this? Well, first we have to remember we have to lay that proper foundation for getting those admitted into evidence. So a proper foundation for admission is required, and it includes all type of photographic media. So the foundation for admitting that photo is going to be, number one, the photo has to be relevant to some point that's at issue in the trial. And the photo must accurately portray the scene. And primary evidence is referred to, remember, over secondary evidence. And the photo must not be unduly prejudicial. And we've talked about that, I think, in other chapters. So remember, in some cases, those photos can't be unduly prejudicial. So remember, as color TV became a common feature in nearly every home, judges became less concerned about inflaming the jury. But now all forms of photography are kind of judged by the same standards, and they must accurately portray the scene without causing this undue prejudice thing. And gruesome photos taken at murder scenes cause the most problems. The pictures that emphasize the gory nature of the crime may be excluded because of their prejudicial impact on the jury. Now, who gets to decide that? Well, the judge. They get to limit the number of photographs, etc., and the type that can be used. Well, but what about like models and maps? And most courts will allow the witness to use models, maps, and diagrams to illustrate his or her testimony. Remember, it was either at the beginning of this chapter or the one before. I think it was the chapter before. We had the officer that was testifying, and he was looking up kind of at a screen when he was testifying. Well, that was a diagram of the scene, the shooting scene. So these things are going to be allowed. And some states permit these objects to be formally introduced into evidence and others don't. And each judge usually kind of retains a great deal of discretion on these matters. Whenever models, maps, or diagrams are used, it's important for the attorney to state for the record what the witness, is pointing to. And if somebody points at something, the attorney may say, let the record reflect or show that the witness pointed to the northeast corner of the intersection of 1st and 2nd Street. And that just kind of helps things go along. And witnesses are allowed to use a whiteboard, perhaps, or a large sheet of paper to draw the crime scene. And after that's done, the attorney might ask questions relating to the drawing. And if scale drawings are desired, those have to be done typically before trial. And sometimes scale models are used. An example would be a model that architects use to show the proposed buildings and their surroundings, and a three-dimensional model showing the inside of a room with all of its furnishings done to scale. And there are anatomical models that are also used to show the trajectory of bullets or the effects of the murder weapon. And a key reason for admitting these types of models is to help the jury. The fact that they are to scale is important because the judge can still decide if they are inadmissible if he or she believes the models would confuse the jurors more than actually help them. And maps and computer generated, say, three-dimensional diagrams or animated videos, these are all common at trial as well. So finally, we kind of look at like counterfeit bills, and I thought this was super interesting, and we're going to finish up here. When you look at counterfeit bills, these are going to fall under documentary evidence as well, and these are going to be evidence to a crime. And I thought it was interesting because if you've never seen a counterfeit bill, take a look at these two. Now they're different, and tell me which one you think might be counterfeit. Now I know it's a color, is a color scanner that I use to scan these. Now one of these is a fake, and one of these is not a fake. And I'll let you kind of look at these and decide. And if you need to look at the backs, you can look at the backs of the two bills. So let me know what you think, and maybe we'll have a conversation about it later. So that's going to conclude the lecture on Chapter 8. And of course, again, if you have any questions, feel free to post the questions on the discussion board. And if you don't want to do that, you can send me an email and utilize the student resources in the book specifically, okay? Read the examples that are underneath each of those larger topic areas to help add context to the lecture and what we've gone over. So with that being said, until next time.